But we've heard evidence from the lawyers for climate change, and I'm just wondering how much more this advisory opinion can help our work, because we've got a report in the next couple of years. And the particular issue that I'd like any of you to speak about is that those lobbying to get rid of the Paris Agreement keep on saying that, look, what New Zealand does doesn't count for anything. We get less than 1% of global emissions. But the tribunal's been told that the countries that have got less than 1% of global emissions to themselves, if you add them all up, there's more than 30% of the global emissions come from countries with less than 1% of global emissions. So I'm just hoping that there's some collective responsibilities from small nations that might be advanced by this advisory opinion. And if so, I'd really like to hear about it.
Yeah, so on the first questions, you're absolutely right. So it was a really cool part, actually, of our Climate Change Response Act that we have codified the 1.5 degree temperature goal within the purpose. In terms of what might happen, I mean, I haven't heard murmurings that New Zealand's going to take that out. I mean, always it's the right of Parliament to legislate how it sees fit, so it could change that, but I don't think that that's on the table at the moment. I think it's worth bearing in mind we have two different targets. So we have our domestic targets set under the Climate Change Response Act, which have to be consistent in our view with 1.5 degrees. Lawyers for Climate Action has an ongoing case asking whether or not our emissions budgets actually meet that obligation. So that is a live issue, and it'll be really interesting. We've sought leave to appeal to the Supreme Court on that. So that will tease out, I think, the real impact and force of that purpose statement. In terms of our international targets, that's separate to the CCRA. I mean, arguably, perhaps that they could be a little bit more combined. The other thing to note, of course, is that we also have the 2050 statutory target. And this is one of the, again, difficult things because, again, Parliament can change that target if it wants to. It can legislate for a different target. And in fact, the government's considering doing that for the methane component of our 2050 split gas target. And it raises questions for the, I think, integrity of the Act. What would happen if you have a 2050 target that isn't consistent with 1.5, but the purpose of the statute is to enable New Zealand to meet a 1.5 degree target? I think that then you have kind of internal inconsistencies within the statute, but that's a drafting problem, and I think would raise quite challenging issues in terms of its interpretation. Just briefly on the second question on the Waitangi Tribunal, I think it's a common retort, New Zealand's too small, it doesn't make a difference. The ICJ actually did comment on that point in particular, and I think that the ICJ advisory opinion would be well worth the Waitangi Tribunal considering. So it made clear that states have what's called respective capabilities and common but differentiated respective capabilities is the kind of international term for countries have to do what they can, but that might differ depending on how big or how rich or how developed or how much you've contributed historically. And the ICJ said that your relative size as a country isn't actually an excuse for doing nothing, and that all states have to pursue their highest possible ambition. And New Zealand, of course, is a developed state. We're an Annex 1 country under Kyoto, and that means we have particular obligations to, under Paris, take the lead on emissions reductions, even though we're a small country.
Kia ora, folks. David, I'm going to answer your question. I really enjoyed the question, and it's made me think quite a lot more about the role of customary international law here. And you might remember there were the two main customary international law obligations that I mentioned, the duty of cooperation and the duty to prevent significant harm to the environment. And maybe a simple way to put it is walking away isn't cooperating. So that would be a big fail. And it doesn't matter what size you are, you're still obliged to cooperate. It doesn't matter how big your emissions profile is, you're still obliged to cooperate. And then the second obligation under customary international law, the obligation of prevention. It applies to every state, and yes, it may require more or less depending on the developmental status of the country and its national circumstances, but it applies to all states, very much as Jessica was saying. A couple of other points that I think are probably relevant from the international law side, from the advisory opinion, was that point the court made, which we really hadn't heard before, identifying that under international law, collectively states' NDCs have to meet the 1.5 degree target. So if there is this kind of interesting new collective obligation, if a state turns its back on that, it really undermines the obligation. It can't be in sync with the obligation. And I guess the final point I would make is a little bit sort of paralegal, if you like, and it goes to that final paragraph of the court's opinion where it said, hey, we're just a court. You know, we haven't got the answer. This all depends on everybody from all the other disciplines and the political will of individuals and groups around the world, which is just to point out that, you know, this whole thing depends on dynamics, and you undermine those dynamics if you assert boldly and loudly and in practice that actually your national economic interests matter more. So it's not going to help in any respect. Whereas the opposite is to seek to diligently try and find a way through this that balances basic human needs in a country that depend on their economy with cooperating and with making an effort, a duly diligent effort. And that will assist the dynamics of the international process, which means that other countries are less likely to walk away, and we're likely to have a less disastrous future than we otherwise might.
So to add a point on the interesting question raised by David, the quasi-judicial, I think you described yourself, role that you're playing. So it doesn't seem like a particularly good argument for anyone to make, the argument you described in the context where the existence of the international obligation is clear. It's owed by New Zealand, and under the Vienna Convention on the Law of Treaties, I think it's Article 26, we can all expect that states will perform their treaty obligations in good faith. So New Zealand, at this stage, subject to something drastic happening, whatever posturing may be occurring politically, New Zealand is in good faith, as we can all assume, seeking to give effect to its international obligations, some of which are set out in the advisory opinion, or at least international law is clarified there, and they include paragraphs 301 to 308, a very clear discussion of the duty to cooperate that Caroline referred to, including at 308, the nice punchy phrase that climate change is a common concern. Cooperation is not a matter of choice for states, but a pressing need and a legal obligation. And so whatever politicization of that position may occur, the legal position seems fairly straightforward, which is we can all rely, as we do in a number of different ways, on the fact that New Zealand will in good faith comply with the international obligations that New Zealand has assumed, and those include the duty to cooperate. And until something drastic happens, New Zealand isn't a rogue state. But the type of reasoning that you were describing is insidious in the sense that it is taking you towards a place where you are essentially, if you were to follow through on it, turning your back on the rules-based order that we rely on as a state in a number of different ways. And I would be surprised if MFAT, for example, lets that occur anytime soon, or at least I'm hopeful they wouldn't.
Kia ora. So we've got a few more questions, but let's keep in time. We'll keep the answers tight too, so that we can get through a few more. I think most of you are up next.
Yes, thanks. Martin, thank you for all this presentation, because I take away quite a lot of it. So thank you very much for that. We heard about several obligations of the states. I tried to pick out two of them. It's the obligation to prevent significant harm to the nature, or to pass on a better world to the next generations. And what actually drives me is what this actually really means. And I like to demonstrate this with an example. So the usage of nuclear power. For a very long time, it was the prime goal of ecological activists to fight against nuclear energy, me included. And currently it's not sure anymore, is it good or is it bad? And in a current judgment, the European Court of Justice found that nuclear energy is actually green and it's a really good thing to do it and have it. So now my question is, if we pass on a better world, do we really know what we're actually doing or what we need to do? And how do we try to measure this? So, and if we cannot measure it, how can we enforce it? So this
Okay. Good.
Thank you.
Good question. Let's have another one or two, perhaps. Thanks.
Jennifer, I was involved with some of the Inter-American Court of Justice work in the advisory opinion there. And I'm interested in what the panel thinks about how much the ICJ thought about the pressure that such an advanced judgment puts on the Paris Agreement, given the really delicate way that the Paris Agreement was negotiated to allow states to have a bottom-up system and to have pressure valves through that system that allowed everyone at least to get around one table. And I worry that some of those pressure valves come under pressure themselves when you have this additional focus from the ICJ. So just interested in whether you see any of that coming through the judgment at all or not.
Fantastic. Thanks, Andy.
Kia ora, my name is Bella, and my question is related to the Paris Agreement's Compliance and Implementation Committee. My main question is related to whether you think now that the ICJ has provided more context at kind of what these normative requirements under the Paris Agreement, I guess, require from state parties, whether you think they're going to be able to expand their kind of fact-finding functions to be able to comment on more of those sort of procedural and administrative kind of aspects, such as whether states actually have a plan to implement their NDCs, because right now they're limited, they're not able to speak on the content of it. It's more like, have they submitted it or not? But I wonder if you think there's scope for that to expand a little bit further.
Okay. Three great questions. The first one kind of exploring, I guess, the challenges in thinking about what's needed from a future generations perspective. If that's not here, our example is this judgment putting too much pressure on the Paris Agreement as it can fall apart at the seams and the compliance committee. So over to that, please.
I'll be quick and then I'll pass on the mic. On the future generations, they broke new ground. They said that states have to have due regard for future generations. That means that in their analyses and their decision making, they have to actually consider what's happening for future generations, consistent with the principle of intergenerational equity that Justin has spoken. That was important. On the Inter-American Court of Human Rights advisory opinion on climate change, I think it's just nice there to actually contrast the two of them. So the Inter-American Court's one is not universal. It is under the Inter-American Convention on Human Rights. The ICJ is universal. And they are of a slightly different tenor. They take the matter seriously in their own way, but the ICJ is much more conservative. And despite everything we've said about what was remarkable about what was in there, they've still been really measured and careful about what they've said, probably to try and navigate the political landscape. But this is such a serious topic that they have felt compelled, as they have worked their way through the law, to point out what they believe that the law requires, and much of that is clarification that we didn't know whether or not we would get. And then just thirdly, the Paris Agreement's Implementation and Compliance Committee. We speculate, don't we, that it might now actually find itself conceivably starting to look at states' NDCs and see whether they are progressive and whether they, a harder question still, manifest a state's highest possible ambition, or at least can they see in the reasoning of the state and the processes it has gone through to produce that NDC a manifestation of, exploration as to whether it's highest possible ambition. Have they looked at the alternatives? Have they done their homework? Yeah.
I think that those last two questions actually overlap in some way, because if you were to beef up the compliance committee's functions, that would really get at what Nicola was getting at in terms of the really delicate, really state of climate international and domestic politics at the moment all around the world. And I think it's possibly a little unfair to have asked the ICJ to have a less bold and important judgment for fear of political backlash, because in some senses the kind of political the political economy of climate at the moment is happening really irrespective of what the International Court of Justice did. The US has already pulled out of Paris. And so I do think that ICJ in some ways puts a bit more pressure on Paris, at the very least because it provides a whole heap of new arguments for domestic litigators around the world and potential new hooks to try and make Paris mean, potentially a little bit more. But I don't know if that means the ICJ should have gone less far than they did. On the first question, I think the part of your question that stood out to me was actually around by which standards can we measure if we're doing right by future generations. And one of the interesting things about the judgment, in my mind, was many interesting things about it, but the judgment accepted the IPCC as being the measure of best available science. And the wonderful thing about the IPCC is they provide, what emissions trajectories do we need to protect future generations and limit warming to 1.5, and what are different sectoral projections and pathways there as well. And I think that provides a really good standard by which we can assess are countries' commitments enough, and do they align with what the IPCC says is required for that? So I think there are actually measurable standards, and that's one of them.
So just to address very briefly Nicola's question, really good question about the pressure that a judgment like this arguably places on a multilateral treaty that is intended to, over a long term, work towards a goal. I think the paragraph that I mentioned, 456, is a good way to access the ICJ, and it's quite self-reflective for a judgment to include the sort of almost anecdotal, this is how we think about it, which is why I like it, because it comes at the very end, but it tells you the way the court's thinking about it. And Caroline just used the word compelled. I think when you read the words, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life. I think the court felt compelled to do something reasonably bold by its standards, and it's a court that is very careful about that, especially in an advisory opinion context where you don't have the factual clarity you might in an adversarial dispute. So I think that's also why you see the court being very clear and very bold and brave in saying, when it's a legal question, it's for us, and you've asked us legal questions, here's your answers. And you can then trace that back through the reasoning and the judgment, I think, and see that manifesting itself, because, as Caroline also said, there's a lot of latitude in how the court expresses the obligation. So everywhere where you see a big step forward, you see the word may. And it's deliberately, I think, framed in a way to allow that latitude to continue to the extent the court thought it possible, knowing that they were putting pressure on Paris, but also seeing it as their job as judges on the ICJ within the international legal order to answer the legal questions they were asked. And I think they felt compelled to do that. And they should have. They are the judges, that's their job, and that's what they did. So I think it's inevitable that you get pressure, because that problem of climate change is putting pressure on everything, not just legal judgments.
If I may, just to that same, well, future generations has been dealt with by Caroline, so don't need to get into that, but just wanted to add with the pressure on the Paris, and I do agree with that as well. Bold and brave, as Rob said. I think the court put a lot of emphasis on the 1.5 degrees. So for me, like 2 degrees temperature warming is out of the window now, according to the court. And I would love to see how this pans out in relations to the COP negotiations that are going to come up in Brazil in November. We're just like 2 months or less away from that. And I think the timing was perfect, and it gives a bit of leverage for AOSIS, Alliance of Small Island States, Caribbean states, Pacific states, to really argue. It gives some scope for negotiation, I think. So the timing was perfect.
Thank you, Justin. So look, there probably are other questions, and the speakers will be here for a little while, so come and harass them afterwards. Caroline, I think, has a few final comments to make, and then I'll do the final wrap up.
Yeah, kia ora everyone. Thanks very much for being here. I just wanted to let you know about a resource. So I have just put on the New Zealand Centre for Environmental Law website a small set of 14 brief papers that cover most of the issues in the advisory opinion. They are actually now combined into a journal article that's been accepted today, that will be coming out in due course in the International Comparative Law Quarterly. But they are nicely packaged up on the website so that you can go in and you can look at reparation, you can look at self-determination and sea level rise, or biodiversity, or customary international law, and you have a chance to at least look a little bit at some of the many issues that we haven't been able to plumb the depths of this evening. So just to let you know that that's there.
So, wow, what a rich and thought-provoking evening. We're so grateful to our speakers, to the Auckland Law School-based ones. It's just an ongoing privilege and pleasure to have you as colleagues. To our external speakers, to Jessica and Robert, we're grateful. Robert travelled from Wellington for this. Jessica a little closer. So thank you. And will you join me once more and thank our speakers? Thank you to Victoria for help and logistics, Maha for running around and also assisting us. Thank you to everyone for coming out on a chilly evening to think about some really big issues. We really appreciate having you here, and we look forward to staying in touch. Kia ora.